Hello and welcome, everyone. Today we are going to look at a decision from the US District Court for the Eastern District of Texas, in a case where we had Collision as the claimant here and Samsung was the defendant. The case started back in December 2023. Collision filed a lawsuit against Samsung before the District Court, and the proceedings initially focused around the infringement of 4 US patents and potential damages out of that infringement. So the case, indeed, in the beginning at least, involved more or less only damage claims for the infringement of 4 patents that Collision asserted against Samsung. This part of the proceedings was decided, in a sense, in October 2025, where the jury delivered its verdict, finding that Samsung willfully infringed the patents that have been asserted here and awarding damages amounting to approximately $445 million to Collision for that infringement. So this was the jury verdict on the damages claims. Shortly after that, in December 2025, Collision also filed a motion seeking a permanent injunction against Samsung. And maybe one interesting note here is that this motion for a permanent injunction was based on only one of the 4 patents that have been asserted initially. The reason for that seems to be that the other 3 patents had a very short remaining term. So if we want to compare it with the damage claims, the claim for a permanent injunction was a little bit more tailored or more limited to the specific one patent. Keep that in mind because the court noted that later on its decision as well. So at that point in time, we had also a request of Collision to be granted a permanent injunction against Samsung for the infringement of this one patent. These proceedings attracted the interest of other agencies of certain agencies in the US, particularly the Department of Justice, the Antitrust Division, together with the USPTO, filed a statement of interest, formulating certain positions there under which conditions injunctive relief should be available also for the infringement of the patents in the US. The proceedings moved on, and with this ruling here from the 17th of May this year, the District Court delivered its decision denying Collision's motion for a permanent injunction. So a permanent injunction was not granted at the end. We have not seen any further developments here in this case, but of course we will monitor anything that happens, and if we have further developments, we will of course cover that in the webinars here as well. Now, let's focus on the legal reasoning of the court. And when we talk about injunctive relief in the US, there is, at least in the last 20 years, one standard that is the dominant one that the courts apply. And this standard is derived from a decision of the US Supreme Court in 2006 in a case between eBay and Merck Exchange. Very shortly here, just to give some context on to better understand the decision of the District Court that we are highlighting today. So here, with this eBay case, with this eBay decision, the Supreme Court laid down a 4-factor test that needs to be taken when there is a request for a permanent injunction against patent infringement. There is a test which has these 4 factors, the first of them being that the plaintiff must demonstrate that it has suffered an irreparable injury. So this is the first factor. You need to show that the infringement caused irreparable injury to the claimant. The second factor is that, again, the plaintiff must demonstrate that remedies available at law, especially monetary damages, so a damage award in money, are inadequate to compensate for that injury. This is the second factor. The third factor is a balancing of interests, more or less. So the plaintiff still is required to demonstrate that, considering the balance of hardships between the plaintiff and the defendant, a remedy in equity, here in our case a permanent injunction, is warranted. And the fourth factor that also needs to be met is that the public interest would not be disturbed by a permanent injunction. Or in other words, that an injunction, if it would be granted, it would not harm public interest. So this is the framework, the general framework that has been applied in the US in the last 20 years regarding this specific question, whether you would have access to injunctive relief against patent infringement. This is, of course, the framework that the court had to apply also in the present case. But before doing that, the court made some general clarifications, which I think are interesting to look at. One key point that the court highlighted here is that in patent cases, we have no presumptive remedy under US law, meaning that there is neither a rule that says that if there is an enforcement, if there is infringement, you need to have an injunction, nor there is a rule that if there is infringement, you only can claim damages. Here, it was Collision particularly that had brought one argument in that direction, saying that if you would consider the development of the law historically, then you would see that, in a sense, the injunction, the injunctive relief, would be the default remedy for patent infringement. But the court said this is not the case. There is no presumptive remedy in patent cases. It all depends, so which remedy is available, on the fact of whether the eBay factors are met or not met. So if the eBay factors are met, then it is possible to have a permanent injunction against patent infringement. On the other hand, if the eBay factors are not met, then the remedy available are monetary damages. Now, looking at how the case law has evolved in the last 20 years after the eBay decision, the court noted, however, that the damages have become the presumptive remedy in practice, meaning that it was not very often after eBay that US court have actually granted a permanent injunction against patent infringement. And in that note, the court added that what you should also consider in this context of the potential remedies that are available against patent infringement is that, according also to the Federal Circuit, there is, in case that an injunction is not granted and you have to be limited to monetary damages, the possibility also to determine damages for the ongoing infringement, meaning damages that could occur from infringement of the patent in the future. And the court noted that the royalties that the courts can determine in these cases are often structured with an elevated or enhanced rate per unit. So the court said, if we want to summarize all of this, there is no default remedy in patent cases. It all depends on the eBay factors, whether they're met or not, which means that you can, in principle, have a permanent injunction if they are met, or if they're not, you will need to stay with monetary damages. But in that case, you will need to consider that under US law, under US case law, this monetary damages can also cover ongoing infringements, or future infringement. This was like an introduction, like setting the scene for the analysis of the individual factors. And let's take a look now at what the court said about each one of them. Starting with the first one, with the question of whether Collision was in a position here to show that the infringement would constitute irreparable harm in the present case. Before turning to that question, the specific one for the specific case here, the court added here also some thoughts more generally of what this requirement or this factor of irreparable injury means and how you should understand this factor. Again, here there was an argument saying that this irreparable injury would be basically there in a sense automatically if infringement is still ongoing. So if the defendant has not stopped infringing the patent in suit, then the argument advanced particularly by the claimant here was to say that the fact itself that infringement is still there, that there is ongoing infringement, more or less automatically creates irreparable injury to the patent owner. The court was not convinced by that, however. It said that there is no categorical rule that ongoing infringement establishes irreparable harm, particularly because this would be something that would not be in line with the eBay decision, which the court highlighted here that refrained from setting up this type of categorical rules, but rather set up broader rules that need an assessment on a case-by-case basis. So the court reiterated here that there is no presumption of irreparable harm and dismissed this notion that if you are in a position to prove that there is still infringement, that there is ongoing infringement, this is sufficient to, in a sense, automatically also establish irreparable harm. So this notion was dismissed here. Another, let's say, more general question that was addressed here had to do with the identity of the patent owner, and particularly the identity of the patent owner, the claimant, as a non-practicing entity. Since Collision could basically fall under this category as a non-practicing entity, the question that was discussed here was generally if non-practicing entities would ever be in a position to establish irreparable injury. And maybe in simple terms, what the argument behind that is, it goes like this. It's the idea basically that if the only reason for having the patents is seeking to monetize them, to get money for your patents, then it is very unlikely, or it can be excluded, that you would suffer irreparable injury through an infringement of the patents, because the only thing that you want to do more or less with your patents is to get money, and this is something that you can do at any time. So this injury can be always, in a sense, repaired by the fact that you will get money for your patents, and considering that this is the only thing you intend to do with your patents, then there can be no irreparable harm. So the court did not agree with that argument. So it again rejected that there is a categorical rule saying that NPEs can never establish irreparable harm. Again, the court saw that this is something that's not supported by the eBay decision, by saying that the eBay decision acknowledges that a lack of commercial activity in practicing the patents cannot per se exclude an injunction. So the fact that you don't really practice the patents yourself, in the sense that you don't have maybe products that are read on these patents that are sold in the market, etc. The fact that this is not the case, that you have no commercial activities, no products based on the patents in the market, does not mean that you have no access to an injunction at all. So the court dismissed again this type of categorical rule. Another interesting point that the court made here is to say that you should also be cautious that the status of a non-practicing entity can be a transient one, meaning that it can be something that can change over time. As an example, an NPE might have been a practicing company, so a company that had indeed products in the market based on the patents and the technology that is covered by its patents, but for any reason they discontinued that and now are just monetizing their patents. You could also think of scenarios where the company might have just have the patents and intends to start monetizing the patents also through own products in the market. So it thinks or it tends to become a practicing entity at a later point in time, or to become again a practicing entity after having monetized its patents in a very efficient way in the market, having collected money to again enter the product market. So all of that is for saying that you cannot have a categorical rule again which would exclude NPEs from establishing irreparable injury or getting access to injunctive relief, because a company can be an NPE today, but it can be a practicing company tomorrow. So this is also, I think, an interesting angle that the court raised here. But maybe the most clear argument of the court against limiting the access of NPEs to injunctions is the fact that the court recognized that there are no two classes of patents. So there are no patents that, let's say, are more valuable because they are held by practicing companies, and a lower second class of patent ownership, which would refer then to patents that NPEs hold. The court noted here that a non-practicing entity has the same right as any practicing patent owner, and at the end of the day, the identity of the owner does not impact the rights conferred by the patent granted. So having discussed these two, let's say, more general questions, the court then turned to the specific case here and the specific question of whether Collision had managed to establish irreparable injury in the present case. And the answer of the court was that it did. So the court confirmed here that at least this first eBay factor was met in the present case. Of course, the court said just providing evidence that there is still ongoing infringement, that Samsung continues infringing the patent, does not automatically establish irreparable harm. So this was not sufficient also in the present case. However, the court said this fact should be part of the irreparable harm analysis, so it cannot be ignored either. And considering this fact on the one hand, that Samsung continued the infringement, and on the other hand, a second element, which the court described as the loss of the design win competition on Collision's side, the court found that these two taken together were sufficient for confirming irreparable harm here. Now, what is this notion of a design win, and what does the court mean by that here? I think to understand that, we need to maybe look a bit on the story behind Collision, because initially what Collision intended to do with the technologies it developed and patented was to not to license directly, but to enter in co-development agreements with manufacturers of cellular equipment, for example, of manufacturers of base station or handset receivers, chips, etc., and integrate their technology into these products. This would be, let's say, what we could understand under the term design win. So manage to get their products, their technology integrated into the design of the products of other companies. And this design win can have, of course, benefits for the company that managed to win this competition, because it can create, for example, a lock-in effect, or the court mentioned also the incumbency effect, and also create a goodwill as the winning supplier of technology. So basically, if we want to put it very simple, if you would manage to win this design competition, if you managed to get this design win, then you could secure to a certain extent your income by the fact that your technology is part of the hardware, in the present case of that other companies have on the market, and this can secure, in very simple terms, income, for example. And the court saw that through this infringement here, and the fact that through the infringement, Collision lost to a certain extent control over its technology, irreparable injury has occurred. Why? Because Collision lost, on the one hand, what the court called the veto power control over its technology, since Samsung was implementing the technology in their own products, and Samsung Collision could not control that anymore, and lost also the design win competition with Samsung, because Samsung could now incorporate this technology in their products, and did not need and could sell this and use all of these positive effects to its own benefit. So the court saw exactly here, through this fact, through the potential losses that could occur from the fact that, in simple terms, Collision was not, because of the infringement, anymore in the position, let's say, to control the fate of its technology and to incorporate it in the products of other companies, which would then help it spread into the market. It saw an irreparable injury coming out of that. So that was the decision of the court, the thinking of the court behind this first eBay factor. Now let's turn to the second one. We said the second one is, can the claimant show that monetary damages are inadequate for basically compensating this irreparable harm? The court again found that Collision managed to establish this factor as well. In general, the reason for that were very similar with the arguments that we discussed with respect to the irreparable harm. So we had again these arguments around the loss of veto power control, or the fact that they lost the design win competition with Samsung. So it was more or less the same thinking, why you could not compensate this irreparable harm that was already established through money. So there's money payment here, and you needed also an injunction to do that. There was some debate around whether Collision's own motions or own lawsuit here might indicate the opposite, because if you remember, we said that Collision had sought initially damages itself, and had also sought enhanced damages in these proceedings. So the question is, by asking basically for money for the infringement of the patents, did Collision admit that money is enough to compensate for their harm? The court looked at that, but at the end of the day, it said it's not sufficient. It's not important or serious enough to just to look at what Collision had asked in these proceedings and say that it basically left or dismissed, waived the possibility to also ask an injunction because they have sought monetary damages before. More generally here, however, I think these three next points which the court discussed are maybe even more interesting, because the court had again to deal with arguments from both sides which tended to create what the court had already dismissed regarding the first factor, this type of categorical rules, meaning rules that do not leave, let's say, much room for individual assessment on a case-by-case basis, but establish a remedy only based on whether a condition is met or not. So the courts found that both parties had the tendency to argue in that way and dismissed the arguments of both parties in that request. More specifically here, there was an argument that damages alone can never remedy patent infringement. This was something that rather came from Collision's side. say that if we want to look at the second factor, then we should accept basically that damages alone are never sufficient. So you don't need to do much again if you would seek an injunction to prove the second eBay factor, because as a rule, damages are not sufficient. The court disagreed with that. It said this is not an acceptable rule. It's again a categorical rule that's not in line with eBay. And particularly, it highlighted here that you have to take into account that under US law, prospective monetary relief is possible. So you cannot say basically that damages are never enough, especially since in the US you have the possibility to get damages for ongoing infringement in the future. On the other hand, there was the other argument, again, in this form, saying that a claimant who licenses its technology and is not a direct competitor of the defendant can never show that money is not an adequate remedy for patent infringement. The argument here was to say that, look, if the business model, if what the party usually does is to just seek for money, and it does not have an interest into protecting, let's say, its own products against the competition in the market through asserting its patents, then it will never be able to show that monetary damages are not adequate. And the court again dismissed that by saying that this is not compatible with the eBay factors, because if you would accept all of this, then you don't really need to go through these factors in a case-by-case basis. And very similarly, the court also rejected the notion that if there is the possibility to ask for enhanced monetary damages, then you should per se not be entitled to an injunction. Again, this very similar idea behind that, but the court again was not convinced by that. So it did not accept that this can be a generally applicable rule when it comes to the assessment of the eBay factors, especially the second one. So this second factor was also confirmed by the court. Let's move now to the third factor. Did Collision manage to show that the balance of hardships would favor injunctive relief in the present case? And in contrast to the first two factors, the district court said no. So the court basically concluded here that the way Collision had brought the case and argued the case did not suffice for showing that the hardships would be in its favor here, in favor of granting an injunction. This balance of interests, more or less, of the parties would be in Collision's favor. Now, generally, the court was not very much satisfied by the way that the parties, both Collision and Samsung, had argued regarding this factor here in the proceedings. It found that both parties made a rather poor showing on this issue. Focused, however, more on Collision's side and the arguments Collision had brought in the proceedings here, but not only. So it also made some comments on Samsung's argument. We're going to see that in a moment. But let's start with Collision and where the court saw deficiencies in the way the case was pleaded here by Collision regarding this specific third factor. Now, the main or one key point of criticism of the court was that Collision did not identify any hardship it would face if an injunction would be denied here. So there was not a specific or substantiated pleading what would happen, what hardship would Collision face if it would not get an injunction as requested here. And this is, of course, an important factor, because this exercise that the court needs to do here is a balancing exercise. So it needs to balance the hardships of each party against each other. And if there is no, of course, indication what the hardships would be on the patent owner's side, it's hard to make this balancing exercise. Collision had made some claims regarding the hardships that Samsung would have to face, almost, or to be more precise, the hardships that Samsung would not need to face, by making the claim that generally, also with regard to this factor, you should not give, let's say, far too much weight to the hardships that the defendants would face, because usually the hardships on the defendants is immaterial. This general claim was not accepted by the court. Here, with the same reason again, the court said that this is more like a categorical rule again, very general categorical rule, which if you would accept, you would basically not be able to be aligned with the eBay decision. So you cannot argue that in any case, or in most cases, hardships on the defendants would be immaterial from an injunction. Looking at more precise, or let's say more substantiated pleadings of collision here, the court was not convinced either. It found that some assertions that collision had made, which were described as bare assertions here by the court, were not convincing in the sense that they revolved around the argument that Samsung would not have much issues, or many issues, difficulties to comply with the injunction, because, as we said in the beginning, the injunction would be tailored here to a single patent. So the argument basically was to say that even if you would grant an injunction, it wouldn't be so dramatic for Samsung. It would be able basically to adapt to that eventually, because it could deal with the fact that it's only one patent that would be covered by an injunction. Apart from saying that this is not really very much specific or substantiated, the court also noted here that this argument would be also inconsistent with what collision itself had argued in the proceedings before, because especially when it came on the damages and the damage claims from the infringement, collision had argued rather the opposite, by saying that there are no alternatives to its technology. So the court saw an inconsistency here by saying, on the one hand, when it comes to damages, that the technology is very important and it cannot really be substituted, meaning that it has a big value, a huge value. And on the other hand, when you are seeking for an injunction, saying that it wouldn't be very problematic to basically adapt to an injunction because it's just one single patent involved that would be part of the injunction, of the injunctive relief. So the court here, apart from, let's say, the low degree of substantiation of these arguments, also saw some inconsistency issues with these arguments. So this was collision's side, but as I said already, the court looked at what Samsung had argued in that context here of this third eBay factor, the balance of hardships, and was not very much convinced either. Samsung had argued from different angles. One angle was to say that an injunction would potentially harm its customers or other third parties, and that an injunction would also impose burdens on Samsung employees, both in the US. Samsung's claim was that in the US it had around 20,000 employees, but also it was an injunction would impose burden on other employees of Samsung worldwide. What Samsung had argued here was that it has around 370,000 employees worldwide. So this was, in general terms, the arguments why an injunction would cause hardships, significant hardships on Samsung, and should be denied here. First of all, the court said this seems to be a mix of arguments. So they found that these arguments clearly conflate the third factor, the balance of hardships, with the fourth eBay factor, which is the public interest. Particularly these arguments about the impact of an injunction on customers and third parties were rather arguments that were suited for the fourth factor, for the public interest factor. But also regarding the other argument, which was, let's say, more Samsung related, regarding the employees of Samsung, and the potential burdens that an injunction would cause on them, the court was not satisfied that this was an acceptable argument here, because on the one hand, it was not very specific. So what would be the burden that would be imposed on the employees by an injunction? But the court also noted here that generally this would be something that would be applicable to the employees, but not to Samsung as an entity. So not really much relevant for this discussion here. Maybe the more interesting point here was the court saying that it had the impression that Samsung's arguments were moving to a direction that it is a global commercial enterprise, and therefore it has a production in many places around the world. It has a business in many countries around the world. It is a big company with a lot of employees. All of that indicating, let's say, an argument that it is maybe too big to be enjoined. But the court said Samsung cannot avoid ever being enjoined because it is a global commercial enterprise, saying that the company size is no material factor when it comes to the balance of interest of hardships here. And the court also did not want to give the impression that there is a protective shield for global companies against injunctions. So all of this type of arguments based on the size and the extent of the business and the spread as a global company in different countries, etc., would not be, in the eyes of the court, very decisive arguments in that context here of the third eBay factor, which would be the balance of hardships. Finally, the court moved to the last point, which was the public interest factor. More specific here, the question whether Collision was able to show that the permanent injunction would not disserve the public interest. And as it was the case with this balance of hardships, the third factor, the court also provided a negative answer here by saying that Collision did not manage to show that the permanent injunction would not disserve public interest. The main reason for that was, again, that the court found that the claimant Collision did not plead facts relevant for the specific case. So the court missed, let's say again here, specific and substantiated pleadings regarding the specific case here. What Collision did was to argue with more, let's say, generalized arguments. Here the court said that what Collision had done basically was to point to the general idea that patent enforcement is usually in the public interest, by arguing basically that an injunction would correct the dynamic that you often see in the market, where parties prefer to go to litigation rather than take a license, because litigation is more attractive, considering that the litigation cost might at the end be lower than the accumulated fees paid under a license. So this was the main line of argument here, to say that generally, again, in a categorical manner, patent infringement and patent enforcement, usually combating this patent infringement, is usually in the public interest. So the enforcement itself, irrespective of, let's say, the special circumstances of its case, has a function of serving the public interest. And this was not something that the court accepted. Again, the court saw here an attempt to create a categorical rule which is not in line with eBay, but it did not see that risk only in the claim that Collision had argued here. Again, what we said before, that injunctions have this corrective function which serves the public interest by not allowing parties to select litigation over licensing, but also rejected something similar that Samsung had seemed to be pleading in these proceedings as well, which we mentioned already, that an injunction against a global company, a big global company, will always harm the public unduly. So not the one extreme nor the other extreme was accepted by the court here. The court said that, again, it's not in line with the eBay judgment, with the eBay ruling, to set this type of categorical rules. You need to very much argue the fulfillment of these factors, and this needs to be on a case-by-case basis, on a very specific basis, and not with this type of generalized categorical rules, which each party tried to argue and put in place in the present proceedings.